Whether the clear evidence that the court has used in absence without arguing for more than 21 days, following which the board took a decision to dismiss it. Following which the board took a decision to dismiss it. There's also clear evidence that since it dismissed, did not receive civil as well, and that goes for both items, then the rest of the system. For the 50. We put it to the beginning of the 50. I don't know so I don't understand what you have got to say.
Oh, my objection is that the case accused as estimated for just now that
We took it from that just now.
there's this information that was not for so that this is related to the dismissed and then it means that she is not for the public court.
Sorry? Elon?
Yes.
Okay.
Hello, this is that council for the things about in life on C objection, and on this end we'll endeavor to reply to the objections raised jointly, and where necessary we shall be separate our responses raised by council on the other side. Along with great safety, Highland friends have not assisted this of Marshall with any law preventing this of Marshall trial of six against persons. We shall, however, endeavor to assist by firstly referring this court martial to section 192 subsection 1
Mm-hmm.
With your leave, my lord, the following persons shall be subject to military law under this act: officers and soldiers of the armed forces, officers of the reserve when called out in service, and reservists called out for training to aid the civil power or on permanent service. While the emphasis firstly will be on A, officers and soldiers of the armed forces. Fast forward along, I will refer you to section 1161.
Mm-hmm.
With your leave, subject to the provisions of section 117, where an offense under this act triable by court martial has been committed or is reasonably suspected of having been committed by any person while subject to military law under this act, then in relation to that offense, it shall be treated for the purposes of the provisions of this act relating to arrest, keeping in custody, investigation of charges, trial, and punishment by court martial, including confirmation, review, and reconsideration, and execution of sentences as continuing subject to military law under this act, notwithstanding is ceasing at any time to be subject thereto. Although there are two emphases in that subsection. Firstly, this court can try somebody who has been subject to military law. All six like who's ever been subject to military law, we say yes. And that came out from the submissions made by my learned colleagues in informing the court that all six accused persons were, as it is, subject to military law. In their own words, they were military personnel who have been dismissed. The second emphasis from section 116, subsection 1, is that a court martial can proceed against the person appearing before that court martial, even though that person has ceased to be a military personnel. I will enjoin my learned friend in relying on the charge sheets preferred against all six accused persons. Are the charges brought under military law? Yes. Are they brought under the acts I just cited? Yes. Now, again, they have not assisted this court by providing any details as to when they were dismissed, if at all. And my learned friend, Mr. H. Kamara, indicated that the fourth accused has since not been receiving salary ever since he was dismissed. Now, the law on that, my lord, assuming without considering at this stage, even if they have been dismissed, and the court martial proceed against them after some point in their life they have been serving members of Rslaf. And the answer to that is yes. And I will refer your lordship again to